Thank you very much for finding the time to join us this morning for our travel industry webinar. It's a data protection update for you this morning. For those of you I haven't had opportunity to meet yet, my name's Lucy England. I joined the travel team and Fox Williams about 3 months ago, and I'm a partner in the travel and our commerce and technology group. I'm not going to be speaking today. I'll be handing over to my data protection colleagues in a moment, but I'll just go through a few housekeeping points. Everybody is muted and your videos are off, but please do send through questions on the Q&A. We'll try and answer them as we go through, and any that we can't answer, we can take offline and get back to you afterwards. Please do ask questions. We're very happy to take them. And this session is being recorded and we will circulate the recording afterwards. So your speakers today are your Fox Williams data protection team. We have Nigel Miller, Kolvin Stone and Ben Nolan. And I'll just hand over to Nigel now, who can tell you more about what you're going to hear today.
Thank you very much, Lucy, and good morning, everyone. And thank you for joining us for the data protection update. Please forgive my slightly croaky voice this morning. It's hard to believe that we have passed the 3rd anniversary of GDPR, and so much has happened since then, not least Brexit, COVID, and Schrems too. So my name is Nigel Miller, and I'm one of the partners in our tech and data protection team. And I'm pleased to be joined by Kolvin Stone, another partner in our team, who I'm delighted to say rejoined Fox Williams last year, having left us to do a few years hard labor in a US law firm. And we're also very happy to have on our panel today, Ben Nolan, an associate in our data protection team. So here's what we're going to be covering today. First of all, very of the moment, COVID-19. Kolvin's going to look at best practice for returning to the workplace. Then Ben will update us on the increasingly complex area of international data transfers and the new standard contractual clauses. I'm then going to look at the current position on cookies and similar technologies and a new EPrivacy regulation. And then back to Ben for a look at recent regulatory actions and fines and what we can learn from them. So first, handing over to Kolvin to look at COVID-19 and returning to the workplace.
Great, thanks Nigel, and good morning everyone. Whilst we've had a delay in the sort of lifting from work guidance, it looks like this week the government have announced that that's all going to change on June the 19th, and we expect the government and employers to start encouraging people to return to the office. And whilst I think not everyone will be rushing back, particularly during the summer holiday, we expect to see more people working from the office. And so with the pandemic still a threat, I think that was very clear from the government's announcements this week that we can expect a 3rd wave as we start going back to more normality. There are a number of things that we need to consider. We're dealing with the pandemic and return to work around employment relations, health and safety, and of course the bit that I'm going to focus on is privacy. So I'm going to look at some of the overarching key issues from a privacy perspective and how you manage employees' return to the office. So really setting out some practical actions and a few frequently asked questions that have come up regularly for us. So the first thing to highlight is the issue of health data. So in managing health and safety matters relating to your employees, there is an inevitable processing of health data. So it's important to recognize that health data is subject to more stringent obligations and responsibilities under the GDPR. So health data can include any COVID symptoms, a cough, a loss of taste, a loss of smell, etc., vaccination records, and any COVID test results, whether they're positive or negative, and temperature test results. That was quite a popular form of testing early on in the pandemic. So it's important to recognize that in trying to safeguard your employees, you're going to be collecting more sensitive information, and because of that, you have to take certain appropriate action to comply with GDPR. So what are those requirements? Principally, you'll be looking at complying with what are called the data protection principles, and I've outlined the main ones here. So the first one is data minimization. So what does that mean? It's reasonably obvious. Keep the data you collect to a minimum. So you're only supposed to collect the information you need and no more to take the measures required to keep staff safe. So in some cases, information will only need to be held for a short period, and there's no need to create a permanent record. So it's a question of identifying those circumstances in where you don't need to create a permanent record. And I'll give more sort of practical guidance on that a little bit later. So transparency is really important. It's a fundamental principle of data protection law, and you need to be as transparent as you possibly can. So employees have a right to know essentially how their information will be handled. And some employees may well be affected by some of the policies and measures that you look to implement. So, for example, as a result of your policies, it may be that some staff are unable to work if they can't work from the office. So you just need to be mindful of this and make sure you tell people how and why you wish to use their personal information and what the implications will be for them. So you also need to let employees know who you will share their information with and for how long you intend to keep it. That can be relevant to some of the government schemes that have been implemented in relation to some of the lateral flow testing. The requirements to share information with government if anyone has actually signed up to that. So security, very important in this context, given the nature of the information that is being collected. You essentially need to keep people's information secure and delete it when you no longer need it. That is something that people don't really associate necessarily with security, but clearly if you don't have the information anymore, there's less risk around it being lost or misused or accessed in an unauthorized manner. So given that the information is more sensitive, additional measures should be considered. So things like strict access controls, making sure that you password protect records, think about the use of encryption, both at rest and in transit, and that's something to talk to your IT security team about. Make sure that certain files are only read-only access, and consider whether additional training is required to reflect the fact that you are collecting more sensitive information, and people need to be given more guidance on essentially how to handle that. So staff rights, as with any data collection, organization must inform individuals about their rights in relation to their personal data, such as the right of access or the right of rectification. So staff need to have the option to exercise those rights if they wish to do so, and hopefully you're just utilizing existing processes and protocols in relation to allowing staff to access data, the additional data you're collecting in relation to COVID-19 health and safety measures. Proportionality and fairness. So you need to make sure that any measures that you are implementing are proportionate to what you're trying to achieve. So make it the least intrusive as it could possibly be. So if you're making decisions about your staff on the health information you collect, you must make sure the approach is fair. So it's really about thinking carefully around the detriment that staff may suffer as a result of the implementation of your policy and your measures and any protocols, and then considering whether you can implement any mitigating measures to reduce the impact on employees, and really making sure that any approach that you implement doesn't cause any kind of discrimination to one category of employees. So next slide, please, Jess. So turning to some of the practical actions that you need to take. So this is really the sort of practical manifestation of trying to comply with some of these principles that I've outlined. So the first one is to provide a supplemental COVID-19 privacy notice to let your employees know about the new uses of data. So this really satisfies your transparency obligations. And we would suggest that it's best to do it in a separate notice rather than sort of hard code it into your existing privacy, employee privacy notice, as the COVID measures and the data you're collecting in that context should hopefully only just be temporary. So what you don't want to do is update your existing privacy notice only to find that hopefully in 12, 18 months, 2 years time, the section dealing with COVID has become redundant. Don't retain permanent records. So for example, you don't need to retain a permanent record of a test results. That is only required to be kept for a very short period of time. So make sure you're implementing protocols to delete records that you don't need to keep. And I think really important in this particular context, and I've seen this in practice, is to discourage the collecting or oversharing by employees of information. I think sometimes in the context of the current situation, it's quite easy for a line manager or even someone in HR to just collect more information than they actually need, or for example, the employee to share information that they don't necessarily need to share. So, you know, for example, you don't need to know the precise COVID symptoms. You don't need to know that someone's got a continuous cough or a sore throat or a loss of smell or a loss of taste. What you need to know is that they are suffering from COVID type symptoms. You know, similarly, if someone has a concern around returning to the office because their daughter has severe chronic asthma, you don't need to know that you know, it is a daughter that has severe chronic asthma. So staff should be discouraged from collecting, and also employees should be educated not to overshare detailed information about their health or the health of their family members. And related to that point is to think about how you record the information that you're told. So if employees do overshare, you don't need to record an example I gave around the employee's daughter having severe asthma. You don't need to record the fact that she's got asthma or the fact it's someone's daughter. All you need to record is the fact that an employee's family member is critically vulnerable and there are concerns around shielding and returning to the office. Carry out a legitimate interest assessment. So this is an assessment that really balances your rights as an organization to use data for the purpose of safeguarding employees in the context of health and safety against the employee's privacy rights. So it balances your rights to use data against the employee's rights. And this is really, really important in terms of forming the legal justification for your use of the data. It's something you need to carry out to prove that you have a legal basis for using the data. Implement high standards for health data. I mentioned there are more stringent requirements given the nature of the data that's being processed. So you'll need something called the strangely titled appropriate policy document. So this is actually a legal requirement when using health data for employment purposes. And you'll need this as a further legal justification for using health data. So it's called the appropriate policy document, something that you need in place. It's actually enshrined in UK law. So enhance your security. I mentioned some of the things that you should consider, and that would require sort of conversations with your IT and security team. So strict access controls, password protected records, use of encryption, read-only access. and train staff on how to handle health data. So the line manager that's having conversations with employees about their return to work and maybe why they don't want to return to work, or your health and safety policy, train the line manager in terms of what information he or she needs and ultimately how that should be collected, recorded, safeguarded, and ultimately also shared securely. Lastly, it's carry out a data protection impact assessment. So this is an assessment that identifies the privacy risks associated with the new activity. So anything new that you're doing in the context of implementing a COVID-19 health and safety policy, that identifies the risks associated with that activity. And then you're supposed to set out any appropriate mitigating actions. So things you're doing to comply with the law. So it would be things like some of the things I mentioned, like include training, enhanced security. Now, there's actually a legal requirement to carry out a DPIA where you are processing larger amounts of health data. So that could well be the case with any sort of health and safety policy that you implement, if ultimately that results in you processing quite significant amounts of health data. Even if there isn't a legal requirement where you're doing something new, which is potentially quite sensitive, it is quite good to do it as a matter of good practice. So next slide, Jess. So just very quickly, some FAQs. So these are the sorts of questions we get asked regularly by our clients. The first one is, can we test our employees? Yes, but that needs to be necessary and proportionate and justifiable for health and safety reasons. So you need to have a very good reason to test your employees. And not surprisingly, there's some of the activities, the compliance activities that you need to go through involve some of the things I've identified earlier. So you need to carry out a legitimate interest assessment, data protection impact assessment, and that will help you identify whether the testing that you are putting in place is legally justified. It's kind of worth noting, and we're starting to see the effectiveness, or get some data around the effectiveness of the vaccination program. But with more widespread and effective immunity through vaccinations, I think it's going to become harder to justify that people are tested on a regular basis. I still think we're learning in terms of the effectiveness of the vaccination, so that's something that just needs to be kept under review. Can you make testing mandatory? I think that's very hard to justify, both actually from a privacy perspective, but also from an employment law perspective, and also given some of those considerations around, whether someone has been vaccinated or not. I'm not going to talk about the government's workplace testing program, because that's now, I think if you haven't signed up to that, it's too late to do that. But that was a scheme that was implemented to promote testing of employees, and was actually quite a good scheme and free, but I think the deadline to sign up to that has passed. So I'm now going to hand over to Ben, who's going to talk to us about the exciting developments in international transfers.
Thanks, Kolvin, and good morning, everyone. So as Nigel alluded to at the beginning of the presentation, the last year has been a pretty eventful period for international data transfers, and a number of significant developments have taken place. Without doubt, probably the biggest development was the Schrems II ruling of the European Court of Justice last summer, and that's what I'm going to spend most time on in this section. The case itself has been pretty well documented by this point, so I won't be going into the facts in any detail. However, from a legal perspective, the case had two main consequences. Firstly, it invalidated the EU-US Privacy Shield as a transfer mechanism. And secondly, and what I'm going to focus on, is it upheld the validity of the standard contractual clauses, but only with major conditions attached, with the court ruling that organisations seeking to rely on the standard contractual clauses need to carry out a transfer impact assessment prior to doing so, to assess whether the clauses would provide an equivalent level of protection for the transferred data. is that provided under EU law? And if that's not the case, then supplementary measures need to be adopted to the extent this is possible. So in the months following on from the European Court's decision, we were all sort of scrambling about trying to decipher what was meant by carrying out a transfer impact assessment and what potential supplementary measures could be put in place. Thankfully, however, the European Data Protection Board published some guidance on the Schrems II decision in November last year, and it's recently finalised that guidance, and this has helped to shed some light on these requirements. So firstly, what's involved with carrying out a transfer impact assessment? Well, the guidance essentially says that it amounts to carrying out a review of the relevant laws and customs which apply in the country of the data importer, and assessing whether these would prevent the standard contractual clauses from working properly. That quite clearly represents quite a significant undertaking for data exporters, since most of the time you won't have any presence in the country that you're transferring data to, and nor will you have any experience of the laws that apply there. And as a result of that, the guidance sort of suggests that data exporters and data importers should work together in carrying out this assessment. And that may be realistic for some large data importers with deep pockets that regularly receive data, the likes of Microsoft and Amazon and the big cloud services providers. But it seems something that would be less realistic for smaller data importers to help with on an ad hoc basis. And we've seen some resistance for smaller companies looking to transfer data abroad to smaller data importers. In terms of the types of laws that are actually relevant for carrying out the assessment, the guidance highlights a handful of positive and negative indicators to be taken into account. However, the issue that's by far given the most attention in the guidance are the public surveillance laws that apply in the country of the data importer, and whether these go beyond what is necessary in a democratic society. And that's not really surprising, because that was sort of the main focus of the European Court of Justice in the Schrems II case. So to help data exporters with this assessment, the EDPB, the European Data Protection Board, has produced some separate guidelines called the European Essential Guarantees that you should have regard to when trying to determine this. Once the parties have completed a transfer impact assessment, then depending on the result of the assessment, they may need to implement supplementary measures if the standard contractual clauses will not be enough on their own to provide an equivalent level of protection for the transferred data. In terms of what types of supplementary measures can be adopted, the guidance essentially sets out three broad types. There's technical measures, contractual measures, and organizational measures. Technical measures are probably the most important of these supplementary measures, as these are the only ones that the guidance says can protect against excessive surveillance laws in the country of the data importer. So examples of the type of technical measures you can put in place include strong encryption of the data, where the data importer, the party receiving the data, isn't actually given the key to decrypt the data, and pseudonymization of the data prior to it being transferred. Contractual measures are essentially what they say in the tin, and means the parties including additional obligations in their agreements with one another to add some protection to the transferred data. So, for example, including additional obligations on the data importer around data subject rights. Organizational measures are especially relevant in the context of intra-group transfers, and refer to things such as having in place group-wide policies to deal with access requests to data from public authorities. So whilst it was useful for the EDPB to issue its guidance, it is somewhat limited where the parties want to transfer data to countries that are deemed to have excessive surveillance laws, and that would include the US. and where those excessive surveillance laws are deemed likely to impact on the transferred data. And that's because the guidance effectively provides that it won't normally be possible to transfer data to these countries in a clear form. And that means in a form that a human can read and access the data. And obviously that's pretty unhelpful, because in most cases when you're transferring data, the point is that the data importer will be able to access it and use it to achieve the purposes of the transfer. So on that, it's worth noting that that's the EDPB's guidance, but the ICO was also planning to issue some guidance on transfers post-SRIMS 2 in due course. And we're hoping that this will be a little bit more pragmatic than the EDPB's guidance. In the meantime, in terms of practical steps you should be taking now, firstly, you should be reviewing the international transfers you carry out. You should be identifying the mechanisms you rely upon to make those transfers. If you're relying on standard contractual clauses, you should be carrying out transfer impact assessment. And where appropriate, where supplementary measures are needed, you should be putting them in place for your transfers. Moving on to the next slide, and another key development in recent weeks has been the publication of new EU standard contractual clauses by the European Commission, and these became effective for use in connection with transfers from the EU on 27th of June. So some of the key changes with the new clauses when compared to the previous standard contractual clauses include the fact that they cover a broader range of transfer scenarios. So the previous standard contractual clauses only covered controller to controller transfers and controller to processor transfers. These new standard contractual clauses also cover processor to sub-processor transfers and also processor to controller transfers. And both of those were very problematic and massive grey areas since the introduction of the GDPR in 2018. The new clauses are also suitable for use by non-EEA entities, which is important because the GDPR has extraterritorial effect. So it was really a necessary change so that non-EEA entities that are caught by the GDPR can actually comply with the GDPR's transfer requirements. Finally, the new clauses take into account the SRIMS 2 ruling, and they require the parties to carry out a transfer impact assessment and include some obligations around that. For example, making the assessment available to supervisory authorities on request. It's important to note that these new EU standard contractual clauses cannot currently be used for transfers from the UK. So UK organisations that are transferring personal data abroad should continue to rely on the pre-existing standard contractual clauses for the time being. And on that front, it's worth noting that the ICO is working on its own set of bespoke standard contractual clauses for the UK, and it's looking likely that it will publish these for consultation at some point over the course of this summer. Once they're approved, it's not actually clear how the new EU and UK standard contractual clauses will interact with one another. And there's a possibility that once they're both approved, you could end up in a situation where you have both the UK and EU standard contractual clauses, which need to be incorporated into one agreement to cover the transfer of UK and EU personal data to one data importer. So that could complicate things even further. Moving on, I just wanted to touch briefly on the data transfer position following Brexit, since the Brexit transition period came to an end at the end of 2020 last year. So next slide, please, Jess. Yeah, and in terms of transfers from the UK, it's essentially the same position as it has been. The UK has adopted all the same adequacy decisions as the EU Commission for the time being, and it also recognises all the EEA member states as having an adequate level of protection. So you can continue to transfer data to these countries without putting in place any additional measures. as just discussed, the ICO is looking at putting in place its own standard contractual clauses for the UK. So that's a change that will be on the horizon in the near future. In terms of transfers coming from the EU to the UK, well, the trade and cooperation agreement that was entered into between the UK and EU did provide for a transitional period during which transfers could be made unrestricted from the EU to the UK, but this expired at the end of June. Thankfully, however, the EU Commission finally published an adequacy decision in respect of the UK last week, just in time for the expiry of the transition period. And that's great news because it means that going forward, data will continue to be able to flow freely from the EU into the UK. The only thing to note on that is, unlike other adequacy decisions, the UK adequacy decision contains a sunset clause, which means that it actually expires after 4 years. And that's because the EU is slightly worried about the UK changing its data protection laws following Brexit, and that's based on some comments that Boris Johnson's made in the past about potentially loosening data protection laws. So that's one to keep an eye on. That sort of sums up the data transfer section of the presentation. So I'll hand you back to Nigel now, who will be discussing some upcoming changes to the EPrivacy framework.
Thanks very much, Ben. So as Ben said, now we're going to look at the regulations relating to cookies. But first of all, why should we care? Why does it matter? Well, first, the subject of cookies is high on the regulator's agenda. So while many of us probably don't care too much about cookies and suffer from cookie notice fatigue, just clicking to get rid of those annoying notices, there has been an increasing number of complaints about cookies to the ICO, almost 2,000 in the past year. Also, the ICO is currently working on an investigation into the ad tech sector, which is largely driven by cookies. And so while many cookies are completely innocuous, others are highly privacy invasive and are involved in systematic monitoring or tracking browsing across devices, or what they call device fingerprinting, and many designed to deliver online targeted behavioral advertising. So the intrusive nature of the technology in some of these applications makes this a priority area for the regulators. So then, as a result of the changes brought in by GDPR, it's no longer possible to rely on implied consent for cookies. The standard required under GDPR is much higher. It requires a specific opt-in. So many of those notices that you still see, which say that you will be deemed to have consented if you continue browsing, are not completely compliant. Then there's the GDPR level fines. Of course, there's nothing like the potentially eye-watering fines that can be issued under GDPR to get this onto the agenda. And substantial fines have been issued in relation to cookies, most notably by the French regulator, with 100 million euros for Google and 35 million euros for Amazon. Finally, cookie law is developing with a new EPrivacy regulation on the horizon, and I'm going to look at that briefly in a moment. So first of all, what is the current law on cookies? Next slide, please, Jess. So the current law is based on the EPrivacy Directive, which goes back to 2002. In the UK, this was implemented as the Privacy and Electronic Communications Regulations, fondly known as Pekka. Actually, the law doesn't refer to cookies anywhere as such. The regulation is technology neutral. It covers a range of cookies and cookie-like technologies. So I'm referring to cookies, but please bear in mind that the regulation is wider than this and doesn't only cover cookies. It covers any technology that can access or store data on a user device. And the device might include smartphones, smart TVs, other devices like connected vehicles or IoT devices. It can also include technologies like tracking pixel GIFs, These are often used in marketing emails so that the marketing department can see whether an email has been opened and whether links have been taken, which provides valuable analytics. So these are all covered by the regulation. The key requirement under Pekka is that where you deploy a cookie, you must first of all provide clear and comprehensive information about the purposes of the cookie. And second, you must get consent of the user. So there are a couple of exceptions to this. The most important one is that you don't need consent for cookies that are strictly necessary for the services requested by the user. That's strictly necessary exception is interpreted quite narrowly. So cookies that are helpful or convenient but not essential, or that are only essential for your own purposes as opposed to the user's purposes, will still require consent. So for example, cookies used to authenticate a user, or to remember items in a shopping cart, or to remember language and other user preferences are regarded as strictly necessary. But cookies for analytical purposes or advertising cookies are non-essential and need consent. Even if consent is not a requirement, users still have to be informed of the use of the cookies through means of a cookie banner and policy or notice. In relation to the overlap between Pekka and GDPR, the important thing to bear in mind is that these are separate regulations, although they do overlap, and consent for cookies is needed whether or not the cookie data involves any personal data. So if it does involve personal data, such as device ID, username, or browsing details, then it's going to be subject to the GDPR as well as Pekka. Under GDPR, you always have to have a lawful basis for processing personal data. And typically for marketing, this could be either legitimate interests or consent. However, where cookies are deployed and processing of personal data is involved, then Pekka effectively trumps GDPR. So that means that if consent is required under Pekka, then consent is also the appropriate legal basis for processing under GDPR. Not an ideal situation, and many, particularly in the ad tech industry, contest whether that's the case, and argue that legitimate interest could be used for subsequent processing, but that's actually the view of the regulator for the time being. So next slide, please. And looking at what do we need to do if we want to sort of check our current status of compliance and make sure that we're in line with Pekka and GDPR. I would say the first thing to do is to carry out a mini cookie audit to make sure you know exactly what cookies you have in use and the purpose and duration of each. It doesn't need to be a big deal, but you just need to be able to identify what cookies you're using, which of those you can treat as being strictly necessary, so you don't need consent. Identify any third-party cookies. So in the case of third-party cookies, such as Google Analytics or affiliate networks, while it's the third party that has the obligation to get consent for the cookie, in practice, the third party relies on the site owner to get that consent for them. Also, identify any cookies which are session cookies and which are deleted once the browser's been closed or you move away from the site, and those which are persistent and remain active, and what the duration of those will be. So all that needs to be set out in the information provided. Review also the consent mechanism you have on the site to make sure it's compliant. Bear in mind the higher standard of consent now needed following GDPR. Everyone seems to do this a little bit differently, and some ways are more compliant than others. More on this in a moment. It's a good idea to review your cookie policy to make sure it meets this transparency requirement, and importantly is actually consistent with the cookies which you've actually got in use. There's no one size fits all for this, as the policy needs to be specific to the cookies which you've implemented and the purposes of those cookies. Finally, you may need to carry out a data protection impact assessment, DPIA, under the GDPR. Kolvin mentioned this a few minutes ago, and also might have application here, particularly if cookies involve personal data that's used for profiling, for marketing, then you may need to carry out a DPIA. Even if it's not strictly required, it's good practice to do so to make sure you look at any particular risks there may be to the data and look at some measures to mitigate against those risks. So moving on to the next slide, how do we get consent? What is this new standard for consent under GDPR? GDPR defines consent as being freely given, specific, informed, and an unambiguous indication of user wishes through a clear affirmative action. So a few quick points. There's no need, as we mentioned, for consent for strictly necessary or essential cookies. So therefore, you don't need to have a pre-ticked box for that. Where consent is needed, the key point is not to use a pre-ticked box because that would not be a valid consent. The user has to do something positive, such as ticking the box to signify that consent. Don't bundle consents all into one. Ideally, there would be granular consents for each cookie, but this can be could be a bit much if you've got a lot of cookies. So it could be for each category of cookies, separate consents with the possibility maybe of doing more granular consents. So there could be also an accept all or reject all button. Now this one's important. Make sure that you don't set the cookies before you get the opt-in. I think this happens on a number of sites that you have a cookie banner, but the cookies get dropped anyway. So you may need to do some technical work on your site or application to make sure that cookies are not dropped, or they're only dropped as and when the user has signified their consent by ticking a box or whatever the mechanism is. Provide clear and comprehensive information. So that was one of the key requirements under Pekka. Also, because if the information is not clear and sufficiently comprehensive, then as well as not complying with that transparency requirement, it undermines the consent, as consent will not be fully informed. Finally, provide an option for users to revisit the consents that they've already given, because consent should be capable of being withdrawn as easily as it was given. So finally, a brief mention of the new EPrivacy Regulation. This has actually been on the horizon since before GDPR came into force, but it's been battered back and forth within Europe without any agreement being reached on the text. It addresses a number of issues such as processing of location data, direct marketing, unsolicited communications, spam, and cookie requirements. So the text was finally agreed in February of this year, and it is now going to the European Parliament. The objective is to update the EPrivacy Directive, which has been around for nearly 20 years, and bring that into line with the GDPR. So it will align the EPrivacy Regulation with the substantial fines possible under the GDPR. At the moment, fines for breach of Pekka are limited in the UK to £500,000. So going forward, the fines will be aligned with the more substantial level of potential fines under the GDPR. It also allows for the potential for claims to be brought by individuals, which could therefore involve the possibility of class action claims. Also, like the GDPR, the regulation provides for extraterritorial applications. So it could apply to businesses outside the EU insofar as it relates to users in the EU. But unlike the EU, unlike the GDPR, it doesn't require that EU users are specifically targeted. Extraterritorial application is triggered as soon as users in the EU are implicated, regardless of whether there was an intention to directly target them. So far as the cookie requirement is concerned, there's still a need for affirmative consent, a number of exceptions, which are a little broader than at present, and include cookies used for the purposes of audience measuring, web analytics, and also cookies for IT security purposes. The regulation also allows for consent to be given by selecting settings within the browser. So, for example, having a white list of sites which the user consents to cookies. But probably browsers will need to develop a little more to facilitate this, but the regulation has it in mind. Also, the regulation provides that users who have given consent must be reminded every 12 months of their right to withdraw that consent. So once the regulation is finalized, there will be around 2 years transition period before it comes into force, so a little way off at the moment. And just a quick view on what the impact is on Brexit. Because of Brexit, the regulation won't automatically extend to the UK, but it's likely that the UK will update Pekka to align it to the EPrivacy Regulation, especially insofar as it's more business friendly and provide additional exceptions. They'll also want to do this, perhaps having an eye on the adequacy decision, which Ben mentioned. Also, because of the extraterritorial application of the regulation, it will effectively apply to all UK businesses anyway, as regards end users in the EU. So one to keep an eye on. That's a quick roundup of the regulation of cookies and the requirement for transparency and consent. And so for our final slot, I'm going to pass back to Ben to look at some recent regulatory actions.
Thanks, Nigel. Yes, so in this section, I'll be covering some of the notable regulatory action taken by regulators in the UK and EU over the last year. In the UK, I'll be focusing on the fines issued by the ICO to British Airways, Marriott and Ticketmaster, respectively. And all three of those companies suffered quite serious data breaches at various points over the last few years. And in all those cases, quite significant amounts of customer personal data, including things like payment details, were breached. And that's what resulted in the ICO taking action in the first place. So as you can see on this slide, the ICO issued notices of intention to fine, which are essentially just preliminary fines to these companies over the course of 2019 and 2020. And under these preliminary fines, BA was to be fined around £183 million, Marriott around £99 million, and Ticketmaster £1.5 million. However, all three companies appealed, and by the time the ICO handed out its final fines, around the end of last year, you'll see that the fines for BA and Marriott were reduced massively by around 163 million and 80 million pounds respectively, whereas the proposed Ticketmaster fine was only reduced by 250,000 pounds. So why were the BA and Marriott fines reduced by so much and the Ticketmaster fine reduced by only a relatively small amount in comparison? Well, the main reason for this was the reduction in the level, the most significant reason for this was down to a change in the way that the ICO actually calculated the fines. For the preliminary fines, the ICO had relied on a methodology set out in an unpublished internal document, which essentially provided for group turnover to be the key consideration when setting fines under the GDPR. However, in its appeal, the BA argued against reliance upon that methodology, and the ICO ultimately decided to depart from it altogether when calculating the final fines. For the preliminary Ticketmaster fine, which was issued in February 2020, the ICO had already moved away from the slightly dodgy methodology, and that partially explains why the proposed fine for Ticketmaster was so much lower than the proposed fines for BA and Marriott in the first instance. So a lot of people had sort of speculated as to whether the pandemic played a significant role in the ICO deciding to reduce the fines against BA and Marriott by so much, especially given that both companies are in the travel sector and have been pretty hard hit by the pandemic. However, the reductions that were attributed to coronavirus only represent quite a small percentage of the fines that the ICO was prepared to hand out. And therefore, we'd suggest that companies shouldn't expect too much leniency from the ICO during this time. Moving on to the next slide, and all three penalty notices that were issued against the companies are all very long, but they all contain some really useful nuggets as to things that the ICO considers businesses should be taking into account in terms of their GDPR compliance. So some of the key takeaways we can take away from the notices include the importance of recognised security frameworks. So all notices refer to guidance from various IT security institutes, including the likes of the National Cybersecurity Centre, OWASP and NIST. And therefore, we'd recommend that all organisations pay regard to these when assessing and setting their own security protocols. Another key takeaway is the importance of acting fast and cooperating in the event of a breach. So BA and Marriott both had their fines significantly reduced, in part due to their speedy action to mitigate the effects of the breach and their cooperation with the ICO. And that can be contrasted slightly to Ticketmaster, which was deemed to have reacted quite slowly to the breach and therefore didn't have its fine reduced on this basis. Lastly, I just wanted to mention the importance of the principles. It's something that the GDPR, that the ICO takes seriously and takes into account when setting fines. And it's also really important because failure to comply with the principles actually attracts the highest level of fines under the GDPR. Moving on to the next slide. And finally, aside from the enforcement action we've seen in the UK, I also just wanted to touch briefly on enforcement action that we've seen across the EU recently. So firstly, in December of last year, the Irish Data Protection Commissioner fined Twitter €450,000 for failing to notify a breach within the required 72-hour time period set out under the GDPR. And that was actually caused by certain of Twitter's staff being away over the Christmas holidays, and it meant that it didn't report the breach until 12 days after it should have done. Similarly, Booking.com was also fined €475,000, and that was by the Dutch Data Protection Authority, and that was also for failing to notify a breach within the required time frame. In that case, Booking only notified the Dutch DPA 25 days after having become aware of the breach, and that was essentially 22 days later than what's required under the GDPR. Another interesting fine that was handed out quite recently in May of this year relates to a Canadian company, LocateFamily.com, and that company uploads individuals' contact details to its website, often without those individuals actually knowing about it. It was fined €525,000 by the Dutch DPA for having failed to appoint an EU representative under Article 27 of the GDPR. And this is a really interesting one to keep an eye on, as following Brexit, there will be a lot of British companies, including travel businesses, that will be offering goods and services into Europe, and therefore will be processing personal data of EU individuals. And those companies may need to appoint an EU representative now under the EU GDPR, and many of them will not have done that yet. So it will be an interesting one to see how the European regulators decide to enforce that going forward. Finally, just another case of regulatory action which relates to Spain this time, and that's that the Spanish Data Protection Authority fined various companies over the course of last year for having failed to appoint a data protection officer where required under the GDPR. And I just wanted to highlight those cases because they tend to show a growing trend in the EU for regulators to impose fines for what we would probably consider quite minor procedural matters in the UK. And that can be contrasted to the position in the UK where the ICO still seems quite reluctant to impose significant fines under the GDPR outside the context of serious data breaches. So yeah, it's an interesting trend and definitely one that we will continue to keep an eye on. That brings us to the end of the presentation today. So I'm not sure if we've got any questions. If so, please feel free to include them in the Q&A, and I'll hand over to Lucy now.
Thanks, Ben and Nigel and Kolvin. Yeah, we have had some questions through on the Q&A. I think we've managed to answer them all, but if you do have more, please do send them in. We've got a few minutes before 10 o'clock and we're happy to stay on if you do have questions, or our contact details are there if you want to take them offline. I hope you've all found this a useful session. There's been lots of practical tips on data protection and COVID. Ben's talked you through the latest on the SCCs, which is very hot off the press and something everybody's getting their heads around. If you didn't know what cookies were before today, hopefully you do now, and what you should be doing with your technical teams. And I think it's been useful, and hope you found it useful to see what the data protection authorities are doing and the fines that are happening across the EU. It is a very changing area, constantly changing, so we'll keep you updated, but obviously do let us know if you've got any questions. We're going to start doing a series of travel webinars, so let us know of any topics that you'd like us to talk about. We're very keen to hear what you're interested in, and tailor topics accordingly. So if you want to ask any more questions, we're happy to stay for a couple of minutes, but otherwise I hope you all have a very good day, and thanks again for joining.